Mr. Speaker, would you do the honors of introducing the Chief Justice?
You're about to see, most of you have seen him before, Chief Justice David Gilbertson. David's a native of Sisseton. He, as far as I know, he's the only person to serve 5 terms on the Supreme Court. He was just confirmed at an election this past June for his 5th 4-year term. He was appointed by Governor Janklow in April 1995 to represent the 5th Supreme Court District. He graduated with an undergraduate degree from South Dakota State University in 1972. And I know he used to bag groceries down at the Red Owl there because he told me he used to help my mom at the grocery store. He got his Juris Doctorate from the University of South Dakota School of Law in 1975. He then practiced law in private practice until his appointment to the Circuit Court bench in 1986. He served there until his appointment to the Supreme Court in 1995. As you may imagine, someone that's so respected and so long tenured in his field, he has had many honors both in South Dakota and across the country. Most notably, in 2006, he was the recipient of the Distinguished Service Award from the National Center for State Courts for his defense of judicial independence. He has also served as a court counselor at South Dakota Boys State since 1995. Chief Justice Gilbertson and his wife Deb have 4 children. Mr. Sergeant at Arms, would you please announce the arrival of the Chief Justice of the state of South Dakota?
Members of the legislature, family, friends in the gallery, and the listening public, please recognize and welcome Justice David Gilbertson.
Thank you very much.
Thank you for that warm welcome. Before we start, I have a presentation to make. I'd like to invite the governor to the podium. Where's the governor?
This is where you get your pledge made.
Okay. All right. Well, Governor, as you're rounding the bend towards the finish line of your service to South Dakota, I want to take you back all the way to the beginning, very beginning, and that is January 11th, 2011. I'm sure you remember the day well. Well, before you went out in the rotunda to take the oath of office, there was a private ceremony in your reception room where you actually signed the oath of office. And I gave you a pen, you signed it, then I attested it, and then all the other constitutional officers did too. Well, then let's fast forward 4 years to January 10th, 2015. The same ceremony was repeated. Once again, you took by signature the oath of office, and I attested your signature. Well, as the truth be known, I'm not really that nice a guy. I had an ulterior motive for providing you with the pen, and that is today to present you with the pen you used to take the oath of office both in 2011 and 2015. Wow. And I had it put in a shadow box, and there's a judicial declaration certifying that this is the pen that you used both times to become the governor of South Dakota, and that I attested your signature. And it's in an antique frame that I had, the type of frame it is, it's probably made from around the 1880s or 1890s, which would be when South Dakota became a state. So, as a souvenir of your distinguished service to the citizens of South Dakota, I'm proud to present you with the pen that made you the governor.
Oh, thank you.
That pen's been sitting in storage for 8 years, so. Okay. Well, Governor Dugard, Lieutenant Governor Michaels, Speaker Mickelson, members of the legislature, constitutional officers, my fellow justices, judges, unified judicial system employees, and all citizens of the state of South Dakota. This is my 17th year as your Chief Justice. This opportunity for public service has allowed me to observe the operations of state government firsthand. The cooperation between the three branches of state government is one reason I believe that government works in South Dakota. Our constitutional tasks are limited by the tasks assigned to the other two branches and the powers reserved to the people. However, we cooperate. This is a far cry from the gridlock and the verbal attacks we see elsewhere. I hope we do not fall into the category that President Harry Truman observed concerning the political environment in Washington, D.C. back when he was president. He said, "If you want a friend in this town, buy a dog." Public support for our three branches of government depends on public education. Sadly, only 38% of Americans in 2011 could name all three branches of state government. That number has now declined to 26%. 31% could not even name a single branch of government. Today, one frequently hears the phrase, the new normal. This phrase does not describe the programs and challenges undertaken by the unified judicial system. Because events and conditions frequently change, very little remains new, and our current situation is not normal. Perhaps a more fitting slogan is the Boy Scouts' time-honored motto, "Be prepared." We must not be overwhelmed by the increasing pace of change. We must always keep our eye on our constitutional tasks. As Warren Buffett once noted, someone is sitting in the shade today because someone planted a tree a long time ago. I suspect that when people think of the South Dakota Supreme Court, they think of written appellate decisions on cases that come before us. It is perhaps helpful to describe how we undertake deciding those cases. When a case is appealed to us, the circuit court proceedings are completed. The trial is over. We do not retry that case. We simply review the evidence and legal claims that were made in circuit court. We only answer the issues that are brought to us on appeal and that were originally presented in the circuit court. We do not expand the scope of the case beyond that. No matter how complex the issues are on appeal, we are simply trying to answer two basic questions. The first is whether there was a mistake made during the circuit court proceedings. If not, we affirm. If a mistake was made, then we have to decide a second question. Was that mistake so serious that it affected the fairness and the outcome of the trial? If not, we still affirm, because under our judicial system, you are entitled to a fair trial, not a perfect one. If a case is reversed because a mistake did affect the fairness or the outcome of the trial, I think there's a general perception that our decision makes the loser the winner and the winner the loser. In most cases, however, where we reverse a decision, the case is sent back to the circuit court for a retrial without the mistake. Thus, a fair trial is ultimately held. We make decisions by majority rule. Since there are 5 justices on the Supreme Court, 3 must agree on a resolution of the case for it to become an opinion of the court. Should a justice feel it necessary not to participate in an individual case, I appoint a circuit judge or a retired justice to sit on that one case. This avoids a chance for a tie and majority rule is preserved. We are also bound by strict rules of appellate procedure. The court must follow laws passed by the legislature and Congress. We do not write laws. We only interpret what they mean. We are also bound by United States Supreme Court decisions on matters of federal law and interpretation of the United States Constitution. If there is a prior decision by the South Dakota Supreme Court on an issue before us, in most instances, we follow that decision. We do not decide cases based on our personal preferences. If we did so, we would become a court of subjective opinions. Under our Constitution, that is not acceptable. The South Dakota Supreme Court is an appellate court that decides cases based on the facts of the case and our interpretation of the law. As a critic of the United States Supreme Court infamous Dred Scott decision 175 years ago noted, judicial tyranny is hard enough to resist under any circumstance, for it comes in the guise of impartiality and with the prestige of fairness. We strive to avoid that. Our judicial system provides continuity and fairness in the appeals process. A new wave of evil has descended upon South Dakota citizens. This evil is the explosion of meth and now prescription drugs. This evil is compounded by the introduction of the deadly drug fentanyl into some existing illegal drugs. In some areas of this state, the ever-increasing horrors of meth addiction are being outstripped by the increasing addiction of prescription drugs. This addiction evil continues despite the best efforts of law enforcement and the court system. The task of helping our drug and alcohol program participants succeed has become literally a matter of life and death. For a second year in a row, we sadly lost a program participant to a drug overdose. It's a bitter fact of life that while we will succeed with a good majority of our program participants, we will not, unfortunately, succeed with all of them. In past years, the consequences of failure of a program participant were continued addiction and a trip to the penitentiary. With the introduction of these more powerful and lethal illegal drugs, the consequences are now deadlier. Nationally, the drug epidemic is at a crisis level. Opioid addiction is overwhelming the public health, child welfare, and justice systems of many states. For example, just one county, Montgomery County, Ohio, it has the city of Dayton in it. They lost 371 people to opioid deaths last year. Just 1 year later, this year, they're on the target to hit 800 deaths in 1 year. As the governor told us yesterday, nationally, 175 Americans die each day from the curse of drug addiction. While South Dakota's fatalities are much lower in number, they still more than doubled between 2007 and 2015. The statistics for opioid abuse are really somewhat surprising to me. This is not a youthful addiction. The South Dakota Department of Health reports that a majority of those people addicted to opioids are between the ages of 40 and 64. The second highest bracket of addiction is the 25 to 39 age group. 80% of the cases involve Caucasians and 57% are women. When we started the drug court pilot program in the Northern Hills in 2008, we never dreamed that the evolution of society would present us with such monumental problems. We certainly had a drug problem in those days, but we considered it manageable. Now it is everywhere, and despite our best efforts, we are once again playing catch up. As President Franklin Roosevelt once observed, there are many ways of going forward, but only one way of standing still. We have a statewide network of drug courts and alcohol courts. Wanting something to work and actually having it work are separate concepts. Our programs are actually working because of the dedicated people who make up the treatment teams for each court. The programs actually work because of the training and dedication of each team member is willing to undertake. In fiscal year 2015, we served 314 people as participants. In 2 years, that number has significantly increased. For fiscal year 2017, it's up to 462 participants. 96 participants have graduated from our programs. So, what's their future on graduation? 82% of the graduates do not reoffend. That is higher than the national average of 75%. It is substantially higher than the rate for people paroled from the penitentiary. That is around 40%. I never tire of attending drug and alcohol court graduations. The compelling life story each graduate has is an example of what can ultimately go right in society. And if you have the opportunity to attend a graduation, I strongly encourage you to do so. You will be impressed. As one graduate once said, I have a completely different work ethic. I show up on time, and I make sure the job task is done right. He concluded, I don't just hurry through it to get the job done. In these programs, we stress and require employment, but that statement by the graduate really summarizes what that means. In South Dakota, our unemployment rate is low enough that most participants can get a job. To keep a job and recognize the importance of a work ethic, that is change. This work ethic is directly tied to earning capacity. Between January 1 of 2017 and June 30th, our 462 participants earned $1.5 million in wages. That calculates to an annual figure of $3 million to support them and their families. That is a far cry from spending in the neighborhood of $25,000 per year of taxpayers' dollars to house each of the 462 participants in the penitentiary. The cost savings do not end there. Of our drug and alcohol court participants, they are parents of 1,219 children, who, if their parents were in the penitentiary instead of our programs, the children would be wards of the Department of Social Services at $10,000 per year per child. That number is up from 707 children last year. Thus, in the past year, this program saved the taxpayers of South Dakota over $12 million in child support costs. Another cost savings from these diversion programs is in health care. The Avera Health System estimates that South Dakota hospitals annually treat about 4,000 people in emergency rooms due to drug overdoses and their complications. Since virtually none of these people have insurance or the ability to pay for emergency medical services, it annually costs County Poor Relief, Medicaid, and the Department of Corrections about $2,800,000. An additional $3.5 million is never paid by or on behalf of the drug-addicted patient, so the cost is ultimately passed back to the paying consumer. In a perfect world, the hospitals would rather focus on other necessary medical needs of patients. Other worthwhile uses for this $6.5 million clearly abound. A circuit judge has been active in these programs since the beginning to find the difference between drug addicts and alcoholics, and there is a difference. In fact, we treat them differently. Although alcoholics are addicted to alcohol, they generally maintain some kind of home and some form of employment. Drug addicts, according to this judge, are couch potatoes. They generally have no job, no home, and nothing more than the clothes on their backs. This comment from this judge is a crucial point in the ability of the UJS to deal with drug addicts in a drug court program. Currently, our program is only outpatient. To get into the drug court program, an addict must have a home and have a job. Sadly, the worst of the worst have neither. We cannot expect those with these addictions to work full-time and move successfully through a drug court program if they are living under a bridge or in a cardboard box. The reality is that they, the most severely addicted, go to the penitentiary because we cannot take them into our programs. I think it's time to consider the development of a concept that would incorporate an inpatient component into our program. It makes little sense to treat the addicted who have a home and, like the priest and the Levite in the parable of the Good Samaritan, pass by on the other side of the road and ignore the person laying in the ditch. As former Chief Justice Warren Burger noted, concepts of justice must have hands and feet. In administering drug and alcohol courts, the unified judicial system has followed national standards and learned from other states' programs. However, when dealing with these uncontrolled addictions and unanticipated situations, there is a bit of the philosophy of boxing champ Mike Tyson. He said, "Everybody has a plan till they get punched in the mouth." South Dakota's population is both male and female, and so is the composition of the South Dakota Supreme Court. In the late 1970s, Circuit Judge Mildred DeMikey of Beaver was the first woman to sit on a Supreme Court case by designation. In 2002, Justice Judith Meyer Henry was the first woman appointed to be a permanent justice of the Supreme Court. At least half the population of South Dakota is female. On April 25, 2017, for the first time, 3 of the 5 designated justices on an individual case were female. That was because one of the male judges had to disqualify himself. Justice Lori Wilbur, Justice Janine Kern, and retired Justice Judith Meyer Henry sat on a case that was orally argued before our court. This was a historic day for the court. We hope to expand our HOPE program. HOPE is a form of intensive probation. It works well in our more rural counties that do not have ready access to treatment services required for successful drug and alcohol court programs. Under the leadership of presiding Judge Scott Myron, we are expanding into additional counties. This is important. I have yet to talk to a rural sheriff who is not facing an increasing amount of drug traffic in his or her county. Addiction is an evil that plays no favorites. It is an equal opportunity disease that affects persons of all ages, sexes, and races. Several of our HOPE programs are in counties that border reservations. They have achieved impressive results with both Native American and non-Native American clients in Charles Mix, Walworth, and Tripp counties. Veterans courts continue to be successful in Cottington County and Minnehaha County. The Minnehaha County program is under the direction of Judge Mark Salter, himself a veteran. Currently, the program only takes veterans who face felony charges. However, serious consideration is being given to increasing the scope of the program to include those charged with high-grade misdemeanors. If undertaken, this could double the size of the program. Further consideration is also being given to taking veterans from counties in the general vicinity of Minnehaha County. Part of the program's success is due to the active participation of the Veterans Administration in Sioux Falls. A VA employee sits on the team that oversees the program. I don't know if you saw it or not, but last week there was a TV news item on the graduation down there. It was very impressive to listen to the graduate from the VA court program. There is a great need for a veterans court in Rapid City. We are currently having 98 veterans on felony probation there. To see if a veterans court would work in that area, we started a diversion program called the Veterans Protocol that can supervise 8 persons who are veterans under a specially trained court service officer. It works well. If funding were available, we could rapidly expand the Veterans Protocol into a veterans court serving a significant number of these 98 veterans. This morning, in the mail, I received an invitation to a graduation from a Rapid City Veterans Protocol to be held this January 16th. They have a fully trained team there, which could expand into a full-blown veterans court if the needed funding of $109,000 could be provided. The pilot protocol program proves that we have a plan and we have people in place to implement a successful program. As was first said over 2,000 years ago, the harvest is plentiful, but the laborers are few. Especially as both of my parents were World War II veterans, Yesterday, I was very moved and impressed with the thunderous recognition from this assembly over the commitment and service to our National Guard troops. Here is an opportunity to follow up on our thunderous recognition with a program that will directly benefit those who have served our country. As Abraham Lincoln once commented, you cannot escape the responsibility of tomorrow by evading it today. Last year, this legislature considered the Mental Health Task Force's report and passed a comprehensive bill to deal with mental health issues and the courts. The law went into effect last July 1st. It will significantly improve how our criminal justice system treats those who come into the system with an underlying issue of mental illness by broadening the definition of those mental illness professionals who can do competency evaluations. The logjam of people sitting in jail waiting for an evaluation to enter a plea will be significantly lessened and hopefully go away completely. It will also reduce the cost of incarceration to taxpayers who ultimately pay the bill for the county jails and their staffing. Speeding up a system of justice benefits all involved. Since South Dakota ranks second from the bottom in the nation in the mental health professional provider to population ratio, we have to maximize the wise use of what limited resources we have. The proposed pilot project for a mental health court in Pennington County did not pass last year. While it was not viewed as unnecessary or ill-advised, the dollars simply weren't there to fund it. Hopefully, funding will be available this year to undertake this project. In other states, these types of programs have proved highly successful and saved significant taxpayer dollars. It has certain common elements with our drug court and alcohol court programs. All three seek to deal with the root problem that got the individual into the criminal justice system in the first place. We need to ask, what happened to you? Not, what's wrong with you? In 2017, this legislature authorized a one-time appropriation to address courthouse security needs throughout the state. Counties are eligible for up to a 50% match for projects to help provide enhancements to safety and security in courthouses across the state. I am pleased to report that 26 counties were awarded these grants totaling approximately $300,000. Examples of projects that were funded through these dollars include metal detectors, bullet-resistant benches, locking systems, security doors, video surveillance systems, panic alarms, and bullet-resistant glass. Improving courthouse security not only benefits those who work in these facilities, but it also protects the many members of the public who transact business in them. The Rural Attorney Program continues to grow and expand. The printed text of my message says we have contracts with 20 counties. I got a good call last night. We now have 21. We just signed a contract yesterday with Dewey County. We hope to expand the number even further in the future. The attorneys who are placed are enjoying the rural counties they now live in and serve. Each year I host a one-day seminar for all the program participants. In visiting with them, it appears that they are satisfied with their decision to locate in a rural setting. Last year, this legislature expanded this program by authorizing placement of attorneys in smaller municipalities. Municipalities with a population of under 3,500 are now eligible to participate, and this program went into effect last July 1st. We are in the process of informing municipalities of the opportunities and benefits of the Rural Attorney Program. Probation is a form of judicial supervision for adult convicted felons and for juveniles. It quietly functions in an efficient manner. There are more people on felony adult probation in South Dakota than in the penitentiaries, the county jails, and the drug and alcohol courts combined. While penitentiary, county jail, and other alternative sentencing program populations have substantially risen, the increase in the number of people on felony probation is measured in the thousands. For example, in fiscal year 2011, the number of cases of felony adult probationers were 5,130. It goes up every year, and if you fast forward to 2017, the number goes to 9,078. It's fair to ask, what happens to these probationers? Well, last year, 84% remained in the program, and 1,862 people were successfully charged or graduated. Of equal importance is the performance of these probationers once they are discharged. For last fiscal year, 83% did not reoffend in the 3-year period following their discharge. Thus, the system does not see them again. As with every state program, cost is a significant consideration. If these 9,078 cases committed by felons in fiscal year 2017 were placed in the penitentiary or alternative sentencing programs, those institutions and programs would be quickly overwhelmed. The state could not afford the increased cost. Yet, if those 9,078 cases committed by felons continue on probation, they are supervised at a cost of $3 per day per probationer. That is a taxpayer's bargain. Not everybody qualifies for probation, nor should they. Dangerous felons, career criminals, sex offenders, and the like belong in the penitentiary. Those seriously addicted to drugs and alcohol belong in our drug and alcohol courts and other treatment programs. Recently, there has been significant public discussion about the passage rates of the South Dakota bar exam. When the passage rate was 80 to 90%, nobody noticed, except the law students who graduated from law school and sat for the exam. Nationally, the passage rates have significantly declined, and South Dakota is no exception. Both the passage rates for the graduates from the University of South Dakota School of Law and the School of Law graduates from out-of-state schools are down significantly. Although there has been a lot written on the issue and more than a little finger-pointing, no single cause for the decline has been isolated. It is likely a combination of a number of factors. I do not have a single magic solution. The Supreme Court is willing to review the situation with other key players in the process, such as the law school faculty, the state bar, and the law students. Our ultimate goal is to provide a quality lawyer who can practice law, hopefully in South Dakota, or if not elsewhere, and provide professional legal services to his or her clients. The South Dakota Board of Bar Examiners has remained stable in its membership. Several board members remain from the glory days of the 90% passage rates. Their approach to grading the bar exam has not changed. All of our neighboring states have also experienced a drop in passage rates. To me, that shows that the South Dakota Bar Examiners are doing their function as gatekeepers, allowing only those who pass the rigorous exam to exercise the significant powers granted to attorneys. Were South Dakota to remain in the highest category of passage, when all the neighboring states experienced a significant decline in their passage rates, it would likely signal that the bar exam in this state is not fulfilling its intended function, the protection of the public, by allowing only those who are academically fit and possess good moral character to assist the public as attorneys. The Supreme Court ultimately oversees this process, and we are pleased with the Board of Bar Examiners' work. South Dakota has always had only one law school, and that has always been on the campus of the University of South Dakota at Vermillion. The executive director of the State Bar estimates that the University of South Dakota School of Law has produced over 90% of South Dakota's attorneys and judges. The University of South Dakota established a committee under the chair of House Speaker Mark Mickelson to study the future of the law school. Monumental changes in legal education have taken place, not only in South Dakota, but around the nation. Rolls of leather-bound law books that were the bread and butter of a legal education and a lawyer's practice are now antiques. Most legal research is now done online on a computer. I think it's clear that the citizens of South Dakota want and need an in-state law school. Where it should be located and how it should function are important questions for study and discussion. Ultimately, the majority of the committee voted to recommend that the law school remain in Vermillion, but create a physical presence in some forms of programs in Sioux Falls. Also recommended were an increased revenue for student scholarships and for the law school itself. Several individuals have asked me if the location of the law school would affect the success of the rural attorney program. I've been involved with every rural attorney placement and have spoken to most of those who participate in the program. In my opinion, the rural attorney program will not negatively or positively be affected by the location of the law school. Last year, I was pleased to report to you that the restoration of the Supreme Court Law Library was well underway. Substantial progress has been made during the past 12 months, and I am pleased to say as of last week, it is completed. I have yet to escort a person into the set of rooms who is not struck by the beauty of the restoration and the original beauty of the facility. These, as far as I know, are the last public rooms in this lovely capital to be restored, and it was certainly well worth waiting for. I invite you to see the project for yourself, and it's really easy to find. It's one floor straight down from the House chambers. If you do stop by, I predict you'll be duly impressed. While it is in large respects a return to the 1911 decor like this room is, it still is a fully functioning modern law library with the latest computer technology for legal research. This past June, Justice Lori Wilbur retired. She left the bench with an impressive record. She is the only person I know who held every judicial position in South Dakota, from a Supreme Court law clerk to a part-time magistrate to a full-time magistrate to a circuit judge to a presiding circuit judge to a justice of the Supreme Court. She did them all with grace and expertise. She provided major contributions to this court's case law by the opinions she authored and participated in deciding. Many of these cases were complex. Justice Wilbur was also a driving force in the growth and expansion of drug courts and alcohol courts. She started the first alcohol court in South Dakota, and when she came to me for funding, I sadly had to tell her I didn't have any money for that program. So she simply smiled at me, went out and found her own funding. That program continues to thrive today. Lives are being saved because of her efforts. She's also made personal visits to every drug and alcohol court in South Dakota. If a program was having a few bumps along the road getting going or was experiencing operational difficulties, she was always willing to involve herself to improve the situation. Justice Wilbur left the UJS a better place than she found it. I tried to coax her up here to take a bow, but she wouldn't come. But she's actually been retired for several months. Justice Stephen Jensen was appointed in September of 2017 by Governor Dugard to fulfill the vacancy created by the retirement of Justice Wilbur. Justice Jensen has been a circuit judge in the First Circuit since 2003 and its presiding judge since 2011. Besides his normal judicial and administrative duties, he implemented drug and alcohol courts at his circuit and contributed to the juvenile justice reforms and UJS technology advances. His tenure on the bench has earned him the respect of many on a statewide basis. The importance of his selection is underscored by the fact that since we became a state in 1889, only 50 people have served as justices on the South Dakota Supreme Court. Please help me welcome Justice Jensen. A couple of weeks ago, Justice Glenn Severson notified us that he would be retiring in June. This is very personal to me as it severs a career path between Justice Severson, Justice Zinner, and myself, as we all started law school on the same day way back in August of 1972, and our careers have paralleled ever since. Several years ago, I was given as a gift a judicial gavel that had a claw head on it instead of the cylindrical one, like this one, that you usually normally see. The person who gave it to me said that he thought it important that judges build things. Justice Glenn Severson certainly qualifies as a judicial builder. As a presiding judge in the Second Judicial Circuit, he oversaw the construction of the final 2 floors of the Minnehaha County Courthouse. On this court, he has been a leader in our technology endeavors. He was instrumental in achieving conversion of the UJS from a paper system to an electronic one. Justice Severson is a modest person and would be quick to point out many dedicated persons were involved in those types of projects. That is undoubtedly true. But without Justice Severson's initiative, such projects would have never come to pass. A thoughtful person, he also leaves a strong legacy of legal scholarship, given the quality of the opinions he authored for the court. Congratulations, Justice Severson, for a job well done. Okay. We did not just welcome a new justice to the UJS last year. We experienced a literal tsunami of judicial retirements. In 1 year, 6 of our 43 circuit judges retired from that position. The governor has named replacements, and I believe, is the most recent one finished, or are you still working on it? Still working on it. Okay.
No pressure.
Just asking.
Doesn't help to count too often.
Well, and we also had 5 of our 15 magistrate judges retire, and they have been replaced. We were able to accommodate the departures through the use of retired judges who agreed to come back as temp help where needed. Sitting judges juggled schedules, and some of the retiring judges agreed to stay and finish their cases after their official retirement date. Thus, we did not experience a backlog of cases. In the UJS, judicial turnover is to be expected. That is how the current justices and judges got their judicial positions in the first place. We hate to lose the years of judicial experience, but we also welcome new blood. Near the end of the Titanic Civil War, President Abraham Lincoln pondered if he controlled events as President of the United States or events controlled him. Every person who has served in public office has faced that question. However, he also mused that you cannot escape the responsibility of tomorrow by evading it today. I believe our actions as public servants are not currently controlled by events, and we are able to move forward to address the public issues that need to be addressed. That is an ongoing process. Those of us in the UJS seek to improve the justice system and the services it delivers to the public. As far as the judicial function in South Dakota, today's message should be evidence that impartiality does not equate with indifference. There is nothing new with this concept. Over 3,000 years ago, the prophet Isaiah declared, "Maintain justice and do what is right." Thank you for your attention.
Senator Curd moves that the joint session be dissolved. Is there a second? Second. All those in favor signify by saying aye. Aye. Those opposed, nay. Motion carried. Whoever put in that the chief would have cited Mike Tyson, you won the pool. Come up and get the prize.
State House program funding provided by the South Dakota Bar Foundation, the educational and charitable arm of South Dakota lawyers and judges.